number 162, matter of Brandes.
May I reserve 2 minutes, please?
Yes, you may.
Please, the court, my name is Chris McDonough. I'm the attorney for Joel Brandes, the appellant herein. Mr. Brandes was denied reinstatement by the Appellate Division, 2nd Department, on the ground that he violated Judiciary Law Section 90, Subdivision 2, and the order of disbarment, which inter alia directed that he desist and refrain from practicing law in any form and from giving to another an opinion as to the law or its application in any advice in relation thereto. The Appellate Division prefaced its opinion by characterizing Mr. Brandes as being a noted authority and expert on New York family law and divorce. It held that because of his
That's true, isn't it, counsel? He is a noted authority.
No question.
Yeah.
But counsel, and I know your position on that is that, oh, because he is this noted authority who is held to a different standard. I have trouble reading the Appellate Division that way. I read the Appellate Division decision to say that's a factor, and it's a factor in looking at, was he really in this paralegal role, however you want to define that. I don't think the title is that important, but in that role he was acting in, was he acting as an attorney or not? And one of the factors they looked at was that he has this expertise that admittedly is more than the attorneys who were working on the case, and they said because of that, I think they were more skeptical that he wasn't acting as the attorney in the case. So they weren't holding him to a higher standard because of his expertise. What they were saying, as I read it, was his expertise is a factor in our analysis of what he was actually doing.
With all due respect, I would say that if you read the opinion, but for his intelligence, expertise, and his writing of the book on family law, he would have been readmitted because the
So is your argument if he was a less capable attorney that he would be readmitted?
Yes, I do.
But couldn't
So
there
he's
be an
being
argument?
punished for his own success then?
I think it's being held against him. I don't know if I'd use the word punishment, but it certainly is, as you say, a factor. But it's a factor that puts him in a singular class all by himself or with perhaps other very, very bright, disbarred lawyers.
Are there any other examples you can point us to where this analysis has ever been used, this particular
You mean
analysis?
a legal analysis?
Yeah, this particular analysis. Is the core of your equal protection argument, am I right?
Well, the equal protection argument is because of the class, and the class itself is undefined and in fact is undefinable. So that's our position, is that it's not a measurable class, and it's a class of one, based on a very amorphous observation by the court. And in fact, if you look at the record, and one of the problems with this case is that we never got the record that goes to the court from the Committees on Character and Fitness. But the transcript of the hearing. Yes.
I don't mean to be rude. I just want to stay on this point because it seems that the depth of his experience is not a condition determining whether or not he's practicing law. You can be an incompetent attorney and be violating the judiciary law and the order of the court just as if you were a competent attorney.
Correct.
Correct.
But the
So you understand why I'm having a hard time with the competence argument.
well, we're arguing that the competence is a non-issue. It's a non-starter. Because whether every attorney...
So the reference to it, the AD was wrong in the reference to it, in essence.
Our position is they were wrong by classifying him as, in that class, separate from other similarly situated disbarred attorneys who are practicing as paralegals. But the other fact is that when we go back to the transcript of the character and fitness hearing, the testimony was not Joel Brandes saying, I'm such a great expert. It was a question, it was colloquy between the subcommittee panel and Mr. Brandes, where they asked him if he is, in fact, an expert or more experienced in the area of family law. And I think, based on his experience for 30 or 40 years practicing in the field, that was an honest answer. But I think that it unfairly now puts a burden on him where he is now perhaps, how would he prove that he was not brighter than the attorney who he gave advice to, especially since the record in this case does not have any testimony whatsoever as to who he gave opinions to and who he worked for. There was reference to perhaps 2 instances, and both of those instances were where he wrote or gave advice to lawyers with very specific insular situations.
So, Mr. McDonough, may I ask you to focus for a moment on the plain language of the disbarment order, which states that, I believe something to the effect that Mr. Brandes can't give an opinion to anyone on the law or the application of the law. How does that fit in?
Well, a paralegal can give advice and do legal research. Let's put that to the side, though.
But I'm talking about the disbarment
Yes.
order
The disbarment order
that
says-
directs Mr. Brandes' future conduct.
The disbarment order says that he cannot violate 487 of the judiciary law, which is the unauthorized practice of law statute. And then it goes on to say, inter alia, that he must desist and refrain from practicing law in any form and giving to another an opinion as to the law or its application or any advice in relation thereto. The key word in this is another. 487, subsection 90 of the judiciary law were all designed to protect the public. And if we look at Dacey, Rowe, and this court's prior opinions, we're looking at protecting the public. Another, as prohibited in the disbarment order, means the general public.
But doesn't it also have another section of that that says, and maybe you said it, and I'm sorry, practicing law in any form, either as a principal or as an agent, clerk, or employee of another?
Yes, it does, but the premise, the precedent to that is you have to prove that he's practicing law. And in this case, we're saying he wasn't practicing law because any non-lawyer, be they disbarred or never barred, can draft papers for a lawyer who then reviews them and signs their names. For example, a law clerk.
So let me get your rule then would be any disbarred lawyer can be a paralegal and work in a law firm.
I would have a caveat to that because I believe, because we have to protect the public, and in my own experience, this is anecdotal, but we want to keep separation between that disbarred lawyer and the client. And in this particular case, Mr. Brandes was in Florida, where it is permitted by statute to practice as a disbarred lawyer can practice as a paralegal, independent and for a lawyer.
Counsel, what I think Judge Fay is asking is, what is the rule that you would want us to adopt for any disbarred lawyer, not just one who's in another state, but someone right here in New York?
I think that in this case, and I would recommend, for whatever it's worth, that a disbarred lawyer be allowed the same leeway and work as a paralegal. However, the appellate division can always, and this court can insist that there be no advice, no contact with clients, no direct contact with clients, no public contact, whatever it feels is necessary to protect the
Why
public.
you have to go out, you know, it's colloquial up in the 4th Department, Ryan, we talk about lawyers and we say they're not even allowed to dust the books in the legal library. I mean, we're pretty strict about staying away. And I get, you know, you've got a unique individual here who's got a great talent that, you know, should be used. But ours is a very bright line.
And when I first started working for the Grievance Committee in 1989, my boss told me the same thing, but that's not the law. And if you look recently at the most recent case out of their office, matter of Weber, there were no charges against Mr. Weber for using a disbarred lawyer, only that he allowed that disbarred lawyer to act in such a way as he engaged in the unauthorized practice of law.
Yeah, you know, there's that case, and you're probably familiar with it, Christensen out of North Dakota. They talk about the situation. They say it seems to say that he could do everything a law clerk or a layman could do except appear in open court. And that seems to be the rule that you're advocating here. And it was referred to as a penalty lightly borne. It seems in New York, while you're right, in some places they have made it later, but in New York, the penalty is much stricter.
I think that the penalty is very strict, but in this case, Mr. Brandes didn't practice law. That is the base of our opinion.
And the core of that is because he was representing lawyers, or he was working with lawyers and not with a non-lawyer.
I would prefer to say that he was employed by lawyers to assist them with specific legal problems. And if we look at Dacey, You know, the interesting language in Dacey, or the controlling language is...
Is Dacey the, how to
The
avoid
probate
probate?
book? Yes.
Yeah.
And Justice Stevens' dissent was adopted by the court, where Justice Stevens wrote that there was no unauthorized practice of law because there was no personal contact or relationship with a particular individual, nor does there exist that relation of confidence and trust so necessary to the status of attorney and client. That is the essential of legal practice, the representation, and
Wouldn't
the
it compare,
advising.
though, to Law in the Family, the book that Mr. Brandis wrote? He's not prevented from selling that, is he?
No, in fact, he writes the supplements for that. But just to finish that quote, the representation and the advising of a particular person in a particular situation, I think, is key. And in this case, Mr. Brandis didn't advise a client with a problem.
Couldn't they take into account the original action for which your client was disbarred? And in that case, it was, I'm not your lawyer. Go to the court and say, I'm not your lawyer, but I'm really your lawyer. And now it's, I'm not the lawyer, I'm the paralegal. So couldn't they take that into account in assessing whether or not your client is practicing law here?
They could have taken that into account, certainly. However, the evidence in the record is such that there was no testimony. The subcommittee, appointed by the committee, recommended his admission after looking at this
Couldn't the
decision.
appellate division take that into account?
Here's the problem with the appellate division, taking that into account, is we were never given the opportunity, notice or opportunity to be heard on the issue. It was not an issue in the statement of, in the subcommittee hearing, and from what we understand, it wasn't an issue in the committee.
But it's an issue in reinstatement, right? That this was the
reinstatement-
conduct you were disbarred for.
The reinstatement statute says that we as petitioners have the obligation to prove by preponderance of the credible evidence that we currently have the character and fitness necessary to be an attorney. Mr. Brandis was disbarred, I think, in 2001. He's lived a very good life since then, very conscientious about his paralegal practice, and in my opinion, it would be very unfair and flies in the face of the statute, which allows reinstatement after 7 years, without a finding that he's not currently, doesn't currently possess the requisite character and fitness.
Thank you, sir.
Thank you.
Counsel?
May it please the court, I'm Robert Cabell, Assistant Counsel to the Respondent, New York State Grievance Committee for the 10th Judicial
Counsel,
District.
what's our standard of review here of the appellate division?
Abuse of discretion, and whether or not there is sufficient evidence in the record to sustain the finding of that court without reaching the merits of the court's determination based on its evaluation of the facts.
Do we have to define what is the practice of law, or more particularly, what is not the practice of law, in order to determine whether the appellate division abused its discretion here?
I don't know that you have to arrive at a dictionary definition of it. What you can do is look at the factors that were considered by the court and determine whether these are factors that traditionally have been viewed as attributes.
Doesn't it
as
seem
indicia
odd
of the
to
practice.
you that if you take what was the standard that was applied here, every paralegal in the state of New York can be charged with illegally practicing law?
No.
Why not? They're
there's
doing
no
exactly what,
equivalence.
let me finish my thought. They're doing
sorry.
exactly what Mr. Brandis is doing, and yet we recognize that we need it. We say it's great. And as I think one of the points being made here is, he's got a double problem because he's so good. That's crazy, in my opinion.
Well, then we differ, Judge. It's not crazy. There is no actual equivalence between a layperson paralegal and a disbarred lawyer working as a
Well,
paralegal.
no, I'm trying to focus on the work. You know, in other words, if A-Rod, you know, who's suspended from baseball, says, you know, what I'm going to do is, you know, is I'm going to go out and teach kids, you know, how to play the game, and somebody says, well, because you're so good at it, you obviously are playing baseball, and you're in violation of the commissioner's rules, people say, stop, right?
There is work that paralegals do beyond clerical tasks, such as doing legal research, preparing memoranda of law, or even drafting legal papers, that are traditionally associated as attributes of the practice of law. However, in the case of paralegals, it's not considered the unauthorized practice of law as long as particular conditions are applied, such as direct close supervision by an admitted attorney, absolutely no client contact, and not exercising judgment towards the client or the client's problem, but following...
Not my paralegals.
All right.
I mean, don't a lot of them say, you got a whack ball out there, and, you know, if you want me to go do this for them, I will, but spare me.
Is the distinction that the paralegal works internally with that law firm, from what your view on Mr. Brandis'
In most contexts, yes, they are working internally. There are contract paralegals who work for smaller firms. But in the case of this appellant, he wasn't even acting as an employee of anyone. He was a freelancer.
Well, but the real distinction is, this is a penalty arising out of a disbarment. If he could have practiced as a paralegal or a lawyer or any of those kind of things before, but because of the particular violations of the rules and the disbarment orders, in point of fact, the right to exercise, to act as a paralegal is a penalty.
Precisely. The disbarment order itself has the language that separates a disbarred lawyer from a layperson. And it's what separates the ability of a disbarred lawyer from operating as a paralegal and a layperson.
You mentioned freelance paralegals,
Yes.
counsel. So do we have those in New York? We probably do. We probably do have people.
We probably do, but one of
Well,
the...
let's say unadmitted lawyers, JDs, who, maybe work for different people, drafting papers or whatever they do. So are they practicing law?
Well, there was the case many years ago, People versus Alfani, that this case determined, where that's very similar. You had a non-attorney who was in the business of drawing legal papers up for the public. And
No, not for the public, for lawyers, for, freelancing for lawyers, not for the public.
Well, if you're speaking of a lay paralegal, yes, a lay paralegal is certainly qualified and permitted to
I'm
do
talking-
such things. But a
Well, what
disbarred
do you
lawyer,
mean by
no.
a lay someone who has a JD but hasn't bothered to get admitted or whatever, they just can't be bothered. And they're earning a living, drafting papers for various lawyers, not a particular employer, but other, a bunch of lawyers.
That person is not a disbarred lawyer, and that's what separates the whole category of disbarred lawyer from non-disbarred lawyers.
Counsel, what troubles me a little bit here is, aren't we getting a little confused with the label side of things? And we're certainly not going to make a rule that being a paralegal is practicing law or isn't practicing law, because I've been in different places, government, non-government, where paralegals mean very different things. So the label paralegal to me means nothing. It can be making copies, which certainly wouldn't be practicing law for anyone. It can be walking into court and doing something which would be practicing law for anyone, not that lawyers would do that. So to me, this is a very fact-specific case, and what we're trying to define the practice of law. The practice of law, the practice of law. And the question to me here is, under these facts, was the appellate division wrong in concluding, as a matter of law, were they wrong in concluding he was practicing law?
No, they were correct in concluding.
No, but isn't that the issue here? It's on these facts.
On these facts, the issue
Was
is whether
this
or not,
person
yes.
practicing law? Not was he a paralegal, was he a disbarred paralegal? It's what he was doing, looking at the practice of law, and is that the practice of law? And did they make an error, a legal error, in concluding that?
I agree with your framing of the issue, but I conclude that the appellate division did not err. They did not err because Mr. Brandes crossed the line. Where he crossed the line was in drawing upon his stock and trade, which was his expertise in matrimonial divorce
So
law in New York.
if he had drafted memoranda on things that didn't involve family law or didn't involve his expertise, that would have been okay?
As long as it wasn't in the context of some real-life client problem, that would be okay. That would be closer to merely publishing a general audience treatise, as he does.
I didn't know if this was an issue or not, but the claim here is that he only did this in Florida, right?
Well, he did it from Florida, yes.
Well, do we have jurisdiction over Florida? In other words, if he goes down there and says, I'm doing what is allowed in Florida, I know I can't do this in New York, but I can do it in Florida, is he in violation of your order?
Yes, he is,
Why?
because the consequences are here in New York.
The attorneys were here in New York.
The attorneys were here in New York.
That he worked for?
His entire website is geared to New York law. He testified at the subcommittee hearing, I only know New York law.
But he didn't, according to your adversary, there was nothing in the record saying who his, quote, clients were, the lawyers that he would give advice to or draft papers for.
Well, I don't know that due process or reviewing the evidence requires that there be a name attached to the client. If the description of the activity is detailed enough to give the finder of fact a notion of what this appellant was doing while he was disbarred and working from his computer in Florida,
If his
then that's
client-
sufficient evidence.
But if his clientele were other, because my understanding of his website was it was all over the world. He got clients from all over the world. That was my understanding. And maybe I'm wrong about that, but what if he had only one or two New York lawyers consulting with him and there were lawyers elsewhere? The bulk of his business came from lawyers
Even
elsewhere.
one instance of the unauthorized practice of law is the unauthorized practice.
Really, you know, that's what gets me. I mean, who are we helping and hurting here? As counsel pointed out, you're disbarred for 7, and then you can come back. And we say, well, wait a minute, you littered. You know, we're not letting you back in for another 5 years. And I realize it's littering, but you said even if he did it once, we're not letting him back. It almost sounds like a vendetta to me.
Well, the record here doesn't indicate that this was a one only.
I know, but
or
you
one
said
of
that.
instance.
You said that.
Well, I was in response to the question.
I know.
There were cases from this court in which one instance only is enough to constitute the practice of law. The separate issue is the one you're raising. Is that enough
Yeah.
to continue to have someone disbarred for more than 7 years? On the facts of this case, the answer is yes.
Mr. Cabot, would you address the issue that was raised with the appellant regarding the plain language, I'm getting back to that, in the disbarment order that directs Mr. Brandes, I think it said not to give to another any opinion as to the law or its application, just that discrete directive?
That's the directive that's contained in Judiciary Law, Section 90, Subdivision 2, which is required in all disbarment orders. And in my analysis of the case, that's the controlling language here. That is what Mr. Brandes did, which he is not supposed to do. It's what separates him, to go back to labels, from a non...
Is that separate from the unauthorized practice of law?
I think that it's an attribute of it. I think that in sort of a reverse way, Section 90 is telling us, up to a point, what is the practice of law. And the practice of law, by prohibiting that activity, the legislature was telling us that that is the practice of law. But I look at it more in the context, the specific context of a suspended or disbarred lawyer, because the giving of an opinion, although that is also the practice of law, in the case of a disbarred lawyer, it's an express prohibition. And that's what separates him from all the other people he wants to compare himself to who do paralegal work.
And is there any authority that defines another?
I could not find a case that focused on that one particular word, but it would seem to stand to reason that another means anyone. You could be giving an opinion to your Aunt Tilly. That's the practice of law. If you're giving an opinion to another lawyer, that's the practice of law under that formulation under Judiciary Law Section 90.
Counsel, how is a disbarred lawyer supposed to know what they can do and what they cannot do if it's just very fact-specific, and I guess you have to look at each. If the decision in this case becomes a precedent for what you can do as a lawyer and what you can't do as a lawyer, would someone who has a particular expertise in some area of the law say, gee, I better not do anything connected with that, because if the decision goes your way as opposed to Mr. Brandes' way, then I'll have been considered to have practiced law
Well,
in violation of my disbarment order?
I think a rule of this dimension might be proper guidance, and it would be that activity by a disbarred lawyer in any capacity related to the law is improper, particularly if that activity draws on any skill, training, or expertise or experience that
If you have
disbarred
a
attorney...
if you have a disbarred personal injury lawyer, and I'm trying to settle a case, and I want to know what his value is, can I call up somebody who's that experienced and say, what's the value you put on this leg-off case?
I think that would be a violation of a disbarment order,
So he'd say, I can't tell you because it'd be a violation,
yes.
even though all we're doing is evaluating injury.
That's correct.
Thank you, sir.
Thank you.
Mr. McDonough?
The definition of another. This court has defined it in Dacey and in Rowe and in El Gamay versus, I forget who there were verses. We have to be, we need to for there to be the practice of law, that the giving of advice is being given to a specific person who has a specific legal problem. In this case, Mr. Brandis gave advice, although there's no testimony as to what he actually did, to a lawyer. That lawyer doesn't have a particular problem. That lawyer has a client. And as we said in Dacey, the practice of law requires the giving of advice to a specific person who has a specific problem. And Judge Stevens wrote there has to be that relationship of attorney and client. Now, the court seems to be implying that, and actually said that because of Mr. Brandis's vast experience, his giving of advice to another lawyer turned that other lawyer into his client. There's no contract, there's no agreement, there's no fiduciary duty that's necessary in every attorney-client
But
relationship.
the Chief Judge quoted that part of 92, and isn't that pretty all-encompassing?
I'm sorry.
The section of the judiciary law, section 92. 90:90, paren 2.
The disbarment order, that the directive that he can't give to another an opinion as to the law. or
Section
documentation.
3 of the disbarment
No,
order.
and again, 487 and Section 90, Subdivision 2 are designed to protect the public. I don't think the enactors of these rules ever anticipated this particular argument, and I think the term another might be somewhat sloppy, and now maybe we need to address it.
Judge Garcia asked earlier, what our standard of review is, and I think someone said that it's, abuse of discretion. Do you agree with that?
Yes.
Okay.
But at this, I think that, to go back to one of the questions you asked, Judge, is it time to define at least what a disbarred lawyer can or can't do? And that is, I would love to see that, because all of my clients, well, some of them actually win, but most of them end up in this situation. And I admit that. But it also points out that in this case, Mr. Brandis did everything he could. And he, if we're all confused, even though he's really bright, he was also confused. And he did the best he could. And this
Counsel,
unfair...
I'm sorry to interrupt you, but I think your time is expiring. On this point of defining what they can and can't do, I mean, one, you have the order, two, you can't practice law. And your client practiced law for a long time. Do we really have to define for him what it means to practice law?
No, but I think, well, no jurisdiction in the country has actually defined the practice of law, and that, of course, is a huge problem. But we can
So what should we do?
define we can define the unauthorized practice of law a little more tightly. We could,
But would it be, you can do a brief, but somebody has to do X? Is that really for this court to define?
that I don't know. I mean, I'm not an appellate lawyer, I'm a grievance lawyer. But in this case, there is confusion, and that it should be addressed.
Thank you, sir.
Thank you.